Your Honor, this has been Kimberly Taylor's motion for attorney's fees and sanctions pursuant to the Texas Citizens Participation Act, TCPA. This lawsuit concerns claims and causes of action that were filed by the plaintiff, Aaron Silva, against Kimberly Taylor for defamation and intentional infliction of emotional distress related to Taylor's alleged publication of court documents from California, which she obtained through a Freedom of Information Act request. These public court documents were published during the Eanes Independent School Board election campaign between the plaintiff, Mr. Silva, and the former co-defendant, Kelly Marwell, who ended up winning that election. As an aside, Ms. Marwell's motion to dismiss under the TCPA was granted by the trial court, and her claims were, or the claims against her were severed into a separate cause number. Ms. Taylor also filed a motion to dismiss under the Texas Citizens Participation Act. Ms. Taylor's motion was denied by the trial court, and appeal was taken to the Court of Appeals in Austin, and the trial court's decision was reversed, and the motion was granted, and a mandate was issued in September. And the case was remanded to the trial court for further proceedings. Pursuant to Section 27.009 of the Civil Practice and Remedies Code, when a motion to dismiss is granted under the TCPA, this section of the Civil Practice and Remedies Code states that the court shall award the moving party cost and reasonable attorney's fees for incurred in defending against the legal action. And this section of the Civil Practice and Remedies Code says that in addition, the court, in its discretion, may award sanctions against the party who brought the lawsuit as the court determines is necessary to deter the plaintiff from bringing future similar lawsuits. In support of our motion for attorney's fees and sanctions, we have several exhibits that were attached to our motion. First, Exhibit A and A1.
Mr. Haynes, I'm gonna stop and interrupt you right there because the court report alerted me to the fact that the exhibits have the wrong naming convention. We use numbers. So D1, D2, D3, there no letters, just numbers. So we'll need to have you renumber and upload them after the hearing. But if you would just go ahead and refer to them by numerals instead of letters, the court reporter would sure appreciate it. Okay, so just for my edification, can I do 1 and 1A or 1 and 1B, or just strictly 1, 2, 3, 4 like that? They need to be numbered. Okay, got it. And P or D, depending on, so yours are going to be D, D01, D02. Okay. So I understand. Your Honor, so the exhibit that we previously marked as A will be Defendant 1, and that is my unsworn declaration in support of our attorney's fees. And the exhibit that we had previously marked as A1 will be D2, and that is our attorney fee bills from my law firm Tyson and Mendez for defending against this legal action on behalf of Ms. Taylor. The bills in D2 total $12,995, which includes 66 hours of attorney and paralegal time, and it's inclusive of an additional 15 hours for preparation of the motion and preparation for this hearing and attending the hearing this morning. My unsworn declaration, D1, and the bills D2 state and show that the fees were charged at the rate of $200 per hour and $225 per hour for attorney time.
and $75 per hour to $112.50 per hour for paralegal time. And the unsworn declaration states that this rate is reasonable and that the amount of time spent in defending this legal action is reasonable considering the type of case this is, the complexity of the issues involved, and that all of the time and fees were reasonable. So the actual bill showing what we did and billed for are attached as Exhibit D2.
Okay, Mr. Haynes, are you offering D1 and D2 at this time?
Yes, ma'am, we are.
Any objection to those?
No, Your Honor.
Those are admitted.
Your Honor, next are exhibits that we had previously marked as B and B1, which will now be D3 and D4. D3 is the unsworn declaration of Jason Snell, who represented Ms. Taylor before Farmers Insurance Company assumed the defense, and he also handled the appeal as well. And his bills from his law firm will be marked as D4. And we would offer defendants D3 and D4 at this time.
Any
No.
objection to those?
No.
Those are admitted.
Next is Exhibit C, which is the opinion and order from the Court of Appeals and mandate. And we would offer those at this time.
Okay, let's identify them by a number, I hope.
Oh, sorry. Judge. Okay, so D5 is the opinion and order from the Court of Appeals and mandate, and we would offer D5 at this time.
No objection.
Admitted.
And then the last exhibit is D6. Which are the documents that we're offering for the court's consideration regarding our request for sanctions. And this is 83 pages of social media and blog posts from the plaintiff, Aaron Silva, published during the course of this litigation and even after the mandate from the Court of Appeals. And we would offer defendants D6 for purposes of this hearing.
Any objection?
Judge, let me ask Mr. Haynes, have you left anything out of that? Any pages excluded?
No.
Yeah, no objection.
Admitted.
Briefly, with respect to the documents attached as Exhibit D6, we believe that these documents show Mr. Silva's malicious intent in filing this lawsuit, and that he was using this lawsuit to drum up support for an additional campaign for the Eanes School Board position that he lost to Ms. Marwell. The blog post published Ms. Taylor's private and identifying information, including her home address and work address. They include calls to action supported by false statements about Ms. Taylor. He also used his podcast to attack her as what he called the Westlake Smear Cartel CEO. And then even after the Court of Appeals reversed the trial court, granted the motion to dismiss, and issued its mandate, even after that, at the end of September, Mr. Silva was still blog posting about this lawsuit and using it to attack his political opponents, including Ms. Marwell. For example, in September 24th, 2025, after the mandate, he does say, "We lost in court, but we reclaimed the public trust. It was all worth it." He goes on to call for people to demand the resignation of Ms. Marwell. And he says the lawsuit was worth it every bit, and we'll do it again if we have to. Those are Mr. Silva's own words published after the Court of Appeals had granted the motion to dismiss and issued its mandate. And so, Judge, we're very concerned that Mr. Silva hasn't learned his lesson, and that we think it's reasonable to expect that if the court does not sanction him, that he will not be deterred from filing similar lawsuits in the future. And so we would request that the court award sanctions in an amount at least equal to what the court awards for attorney's fees in this case. If the court is convinced after reviewing these documents that he will not be deterred otherwise. And Judge, I don't know if Mr. Snell may want to add something about his bills that I didn't bring up.
I don't have anything to add, Your Honor, unless Your Honor has any questions about my invoices. We do, we most likely are going to have rebuttal in response to some of the objections that have been raised to our invoices.
Okay. Well, you might want to save the time for rebuttal then.
Okay.
All right. Mr. Stick, you may proceed.
Well, Judge, did the court rule on D6?
I believe it was admitted.
Yes.
That's
I
what
mean,
Mr. Haynes was just talking about? Those
Right.
Yeah. Um,
the social media posts, you didn't object, so they were admitted.
right, okay. Judge, I've got only a few brief comments. My argument's laid out in the brief, and I'm not going to waste the court's time, or Mr. Snell's or Mr. Haynes's, by re-arguing those points. I would, however, like to mention that in addition to the arguments that we've made in the response to the motion for attorney's fees, the information that Mr. Haynes has just provided on Mr. Silva's comments about it was worth it and we would do it again if we have to. I would like to point out, Judge, that those are completely contextual, and the court should read the entirety of the comments in order to get an understanding of what Mr. Silva was actually talking about, which was we would do it again in that context means stand up for our rights, defend what Mr. Silva believes to be his constitutional right to protect his reputation. Judge, beyond the arguments in the response brief, I wanted to make one final point. I think it is important here to take a step back and look at what happened. Mr. Silva ran for office, which, as this court knows, is a big step. I mean, when you make the decision to run for office, it comes with the risk that you put yourself out in the community for approbation, disapprobation, hatred in some cases. It's a big decision. And he decided to run for whatever reason. And in response, he got shellacked by misleading information. I mean, look, you know, I'm not going to tell the court that I agree with the appeals court decision or the lower court's decisions in whether or not this was defamatory. But they made the decision. We understand it. We get it. We expected to have a fight, and you know, we got it, and we lost that fight. But the fact remains that Mr. Silva got shellacked. Whether it's defamatory or misleading or anything else, those publications about him were designed to attack him personally. I don't think anybody here involved in this case who knows Aaron Silva thinks that he beat his wife. And to say that about somebody, you would expect that person, the recipient, to respond. And Mr. Silva did respond, and he responded by saying, "I'm not a wife beater. That's untrue." And every time he responded, he got shellacked again with more misleading information. Look, in politics, you either respond and deny something, or it's true. I mean, it's hung around your neck as though it's true. And I think it's important to remember that Mr. Silva was defending his reputation. He's married, not to that woman who is the alleged victim of his abusive behavior. And he had to do something, Judge. He had to explain to his wife and to his kids that he didn't hit anybody. Certainly not the woman he's married to, and not anybody else. So I'm mentioning that, Judge, because in the context of sanctions, the behavior has to be egregious. It has to be outrageous. It has to be offensive. And it's not. Mr. Silva defended his reputation. That's normal. In terms of the attorney's fees themselves, Judge, as detailed in the response, we're looking at charges for things that would have occurred whether or not that TCPA motion had been filed. Those are disallowable. They're not disallowable, they are disallowed. Just as filing and receiving and insurance correspondence are all disallowed. We broke them into categories, Judge, and we would ask that the court review our comments about the necessity of double billing and billing in the other violations. Judge, I think most of these are disallowable, and I would ask that the court scrutinize it and in the end disallow those expenses. Thanks.
Okay, Mr. Haynes?
Your Honor, I disagree with Mr. Stick. I don't think Mr. Silva's response was a simple denial and defense of his character. I think it went way beyond that. But it's not my intent in this hearing to relitigate, the underlying facts. I think that's been decided. But as far as our billing records are concerned, we do stand by our billing records. They explain what we did in the defense of this legal action, which is what we're allowed to recover for. They explain why we did it. And I think would be pretty apparent to any lawyer reading the bills that it was all done to defend this case. Mr. Stick didn't mention it, but he does in his response. He mentions that we didn't segregate our bills. And my understanding, and I may be wrong, but my understanding is that segregation is only required when there are claims that are both where attorney fees are recoverable and claims where attorney's fees are not recoverable. And then you have to segregate which attorney's fees have to do with the recoverable claims and which ones have to do with the non-recoverable claims. That isn't this case. We're allowed to recover attorney's fees for defending this legal action, and so we didn't segregate any of them because they're all go to that one singular claim that's the basis of this lawsuit. And I don't have anything else at this time, Judge. Thank you.
Okay. All right. Okay. I don't need anything else from you. I'm going to review the application in further detail. Counsel, do you have a proposed order?
Yes, Judge, we did file a proposed order yesterday.
Okay. And if you could if you haven't emailed that, if you could email that to my staff, that would be helpful. If you have a version in Word.
I
But
will
I
get
will,
that, Judge, and I will also get the exhibits numbered and resubmitted.
great. The court reporter will appreciate that. Thank you.
And I won't make that mistake the next time I'm in Travis County.
Okay, yes. P and D and numbers, no letter.
Okay,
All right,
got
well,
it.
thank you. You'll probably hear from me within, I'll hope to give you an answer within a few days. But I do need to go through what you've submitted. Y'all are excused from the virtual courtroom. Have a great week. Take care.
Thank
Thank
you.
you, Judge. Thank you for your time.
This is a case based on a student loan agreement between the defendant, Susan Lindsay, and Laurel Road Bank, which was signed on or about November 1st, 2018. On or around January 29th, 2019, Laurel Road Bank entered into a student loan purchase and sale agreement with Key Bank, which is the plaintiff today, to purchase the outstanding loans that were owned by Laurel Road Bank. We've attached a bill of sale as well as a student loan schedule to our second amended motion for summary judgment on, defendant made consistent payments from the time that she signed the loan through December 13th, through March 2020. And then she made sporadic payments. However, her last payment was made November 2021 pursuant to the agreement that Ms. Lindsay signed. When she remains in default for at least 90 consecutive days, then the plaintiff is entitled to accelerate the loan. On or about July 13th, 2021, defendant remained in default for 90 consecutive days, and our client filed suit on December 1st, 2023. As of today, the outstanding amount is $142,751.15, and that is the balance that we're asking for today.
Okay. All right, Mr. Bryan, you may proceed.
Well, are they admitting any evidence that it?
It's a summary judgment hearing.
All right. So there's attached to their amended summary judgment is Exhibit F, which purports to be a business records affidavit, which would, apparently authenticate the records or the other exhibits that they attached to their motion. There's a lot in this Exhibit F that I would object to as hearsay. Like the very first page is your standard business records affidavit language. But there seems to be a lack of personal knowledge that the witness displays, because on page 2, it refers to attached as Exhibit F is the original or exact duplicate of the original official certificate of the Office of Comptroller of the Currency evidencing this merger. But the Exhibit F is the affidavit. There is, I'm not sure what the affiant is referring to. There is no such document included anywhere in their exhibits. Also on page 2 of this affidavit, on line 3, it refers to the same document under Exhibit B, which also doesn't exist. And then beginning at the end of page 2 and really throughout the rest of the affidavit, there's language about the total amount owed and the defendant entering into an agreement, things that should not be included in a business records affidavit because they would be considered hearsay. Language such as plaintiff is the owner and holder of the agreement. Defendant failed to make timely payments. That kind of language would be, we would ask to be stricken from the affidavit. I think the bigger issue is a lack of personal knowledge that this witness is displaying by referencing exhibits that do not exist. So that would be an objection to their affidavit.
Okay. Mr. Bryan, I didn't see any objections that you filed. Objections to summary judgment evidence need to be filed in writing with the court.
Okay. I guess moving on to what's really at heart here is the fact issues that would relate to the chain of title on the account. And they did include a bill of sale, which I think is referred to as Exhibit B, which purports to sell her account, Ms. Lindsay's account, from Laurel Road Bank to Key Bank. And it references an Exhibit A that would be attached that would show her account as being an account that was sold. And Exhibit A is attached to the bill of sale, but it's blank. So there is no record of her account being transferred from Laurel Bank to Key Bank, which would be what I would consider a material fact issue here. This is whether or not they have the capacity or standing to file the lawsuit.
Okay. All right. I guess Ms. Lang, will turn it back to you if there are any final words on the motion.
Your Honor, the only thing that I would add is that the bill of sale references Appendix A and Appendix B, which we attached as Exhibit C so that it wasn't confusing. Well, the goal was for that it was to be less confusing because Exhibit A to the motion is the student loan agreement. And so Exhibit C is the schedule that includes the defendant's account.
Okay.
And if I just may, Your Honor, that exhibit, which is labeled as Exhibit C, does not include any account particulars that pertain to the defendant's account. Does not reference the defendant's name, defendant's address, defendant's social. The account number doesn't match up with what's on the actual agreement. There's case law that discusses this specifically for debt buyer type cases, where these boarding documents or sale documents where the accounts are supposed to be listed, you have to list expressly the account and the information that has to be listed. And it's not. There's no name. All it lists is what I think is an account number that I can't find anywhere in their documents and a balance owed. So there's case law cited in our response that discusses this expressly. If they're going to allege the sale of an account, it has to be certain that this account was one of the accounts included in what I guess would be a group of or a pool of accounts that were sold. And that would be a very material fact issue here.
Okay. All right, Ms. Lang, anything else in response to that?
Your Honor, in response to that, I would just mention that the banks are limited by regulations by what they're allowed to enter into public record, particularly when there's a pool of accounts that are purchased. They have to make sure that they protect the identity of all of those other debtors. And so I appreciate Mr. Bryan's mentioning the case law, but I would want to bring up that the regulations are relatively strict regarding what we're allowed to enter into public record when we're attaching these documents.
Okay, and so when I go to review the summary judgment record in this case, all I see is the second amended motion that plaintiff filed at the end of October. And Mr. Bryan, there is no response on file from the defendant?
So our original response was filed in January of 2025. This summary judgment history is long. We did not file a response to the amended motion because our original response still applies. There's nothing really changed in their amended motion for summary judgment.
Okay.
We made the same arguments about the capacity and the chain of title in the case inside of the case law in that original response, which was uploaded to well this morning to the Dropbox.
Okay, so Ms. Lang, I think what Mr. Bryan is telling me is that the original response he wants considered as a part of the summary judgment record. Any objection to that?
No, Your Honor, I don't have any objection to that. I have his response from January. I think that the second amended motion addresses the issues that were raised in his response.
Okay, I'm going to take this under advisement and I will let you know when a decision has been made.
Thank you, Judge.
Thank you, Your Honor.
Y'all are excused. Have a good week.
Thank
Thank
you.
Thank you.
We were presented an agreed judgment on this case. And I had some questions about it, and that's why you were invited to appear here this afternoon. So the proposed agreed judgment indicated that the parties have entered into a settlement agreement. Is that correct?
Yes, Your Honor.
Okay. And the proposed order that the court received had both a monetary judgment against the defendant as well as foreclosure on her home.
That is only if she fails to remit payment under the payment plan.
Okay, well, that's not how the order is drafted. I have the order in front of me. I don't know if you have it in front of you, counsel, but it does not appear to me that it's written in a if-then fashion. In other words, I think the order that's drafted gives the defendant at this time both a monetary judgment and a right to foreclose on the property. And that appears to be different from what you just told me, which I think the settlement is if the monetary judgment is paid, then you're not going to foreclose. And that, I don't think that's the way this is written. And that's why you were called in here this afternoon.
I understand that now. I was like, I don't know why she's calling us in. So that makes a lot more sense. Let me just review this real quick one more time. And let me just look at the payment plan. So in our payment plan, it does state that the agreed judgment just secures the obligation to pay.
Okay,
But
well,
we don't execute on the agreed judgments if the payment plan is fulfilled.
I'm sure that may be the case. However, the judgment that you submitted to the court contains no conditional language. It allows both the money judgment and the foreclosure. Foreclosure is not conditioned.
In the payment plan, it says, if you default on the payment plan, the association may pursue all remedies, whether in law and equity, including but not limited to the foreclosure, otherwise enforcing the terms in the agreed judgment. So I guess we could file this with the court as well, if that would help, or you can modify the agreed judgment to make it conditional on the payment plan being paid timely. I would be okay with that, and I don't think I would need to appeal that modification. But I do see what you're saying.
Yes, this allows you to do both things right now. It does not have any conditions. I don't think, based on what you've told the court, it's not consistent with the settlement agreement. It also, I believe, would amount to a double recovery, both the monetary judgment and to foreclose on the property. So yes, if you want to send in the judgment in Word, if you want to revise it so that it has conditional language, that's fine. If you want the court to do it, that's fine, but I don't I think the relief that is in the proposed final judgment right now goes beyond what the parties' settlement agreement contemplates and goes beyond what the court is going to order.
I totally understand what you're saying. I will go ahead and send in a Word version, and then I'll send a Word version in, and then also I'll add in my proposed conditional language for you to review. And then you can just execute that, or modify that as you see fit for the conditional language. And I would just like to mention for the record that I've had this issue with a couple of other judges, that if the foreclosure relief is stricken from the AJ, then I do have to appeal the agreed judgment, because that's the only way that we can recover if she does fail to pay on the payment plan, which puts us in a bind for recovery if she fails to pay, and then we can't enforce the judgment as well through foreclosure, which is the relief that is prescribed in the declaration. So I would just like to mention that. But I am totally okay with adding the conditional language for the payment plan and adding the payment plan as an exhibit, if that helps as well.
Yeah, I think that would be helpful. And I think the money judgment for the amount that the parties agreed to makes sense. But the problem with the foreclosure is the judgment is not conditional. It allows you to do everything tomorrow. And that's not what you told me is the agreement. And I think it also
Correct.
likely exceeds would be more than one recovery, which is prohibited by Texas law. So
Absolutely. And that's most certainly not how we practice, but I definitely see your interpretation. So I'll correct that for you.
okay, thank you.
If that's all right with the defendant, I would just like to see if she wants to see the language first. I'll CC her obviously to my email to the court, but I just want to make sure with the defendant if she wants to see the language first, or if she's okay with me sending you the Word version and you modifying it as you see fit.
I trust your judgment in the correction, so no
Okay.
need to send that over. Thank you.
All right, sounds good.
Ms.
I will
Gorey.
CC you on our email to the court though, if I have your email.
Sounds good.
Okay.
All right. And Ms. Gorey, you understand what the concerns were that the court brought this afternoon?
Yes, Your Honor, I do understand.
Okay. And you understand we're gonna modify the judgment so that it basically matches the agreement that the parties have reached.
Yes, I do
Okay.
understand. Yes.
And the only way for you to avoid the foreclosure is to pay the amount due and owing under the payment plan.
Understandable.
Okay. All right. Fair enough. Well, these are really important cases, and I just think it's important that everybody understand going forward what could happen or what the agreements are. We'll look for your email, Miss Applegate, with the revised judgment. And seeing nothing else, y'all are both excused from the virtual courtroom.
Thank you so much, Your Honor.
Thank you, Your Honor.
All right. Take care.
So this case has been on file for over a year at this point. It was filed October 8th of last year. Defendants finally answered almost 3 months later in late January of the following year. Then this motion was filed in July of this year and set for hearing originally early October, but defendant failed to respond timely. And then also just a few days before the original hearing, they motioned the court to continue the hearing, reschedule it, which was granted. And so here we are today. In our motion, we assert that, with our exhibits attached, that we meet all of the requirements to show that they've breached the loan agreement. I think the biggest issue before the court today is the certain balance that's due and owing. So in defendant's response to our motion, they don't, dispute that they're liable on the loan. It's really an issue of the amount due and owing. And so, Judge, if you don't have any questions for me about the motion, I'd like to sort of jump into the response and the reply for time's sake, because I think that's really where the issue lies.
That's fine.
So the defendants, in their response that was filed last week, they attach an affidavit that's basically saying that they're challenging our numbers, right? Our damages, but they don't provide any evidence or any factual basis saying that our numbers are wrong. They basically just assert that they're confused about our numbers. Additionally, the motion to strike that I mentioned, which was the reason for the record, as to the value of the condominiums, which is the property at issue of the case, that was the collateral for the loan. They have the defendant provide what purports to be expert testimony as to what the foreclosure sale should have been. And we motion to strike that because it is not expert testimony. They don't properly provide any comps, or they don't establish it as expert testimony. And to the extent that they might argue that Diaz is the owner of the property, he's not the owner of the property when they put this evidence on, as he lost title in the foreclosure. So to that extent, the plaintiff moves to strike paragraph 9 of defendant's affidavit.
Okay. Well, I'm going to hear the response to that first. So, Ms. Love, I guess we'll go ahead and hear from you. Oh, you're on mute though.
Sorry about that. So I wanted to point out a couple of things with respect to Defendant Diaz's testimony and his declaration. One is that he is the managing member of Arev LLC, the second defendant in this case, and Arev owned the property at the time of the foreclosure, and that the opinion testimony as to valuation is from the time when Arev was the owner of the property and Mr. Diaz was its managing member. So I do think that as an owner, you can provide testimony as to valuation, which is what he has done. And Your Honor, are you only asking me for my response to the motion to strike right now?
I'm sorry, I'm having a little bit of allergy problems right now. You can respond to one or the other or both. It's up to y'all. Sorry.
Well, no, I understand. Cedar is incredibly high this year. So the calculation of damages is in fact the only issue that we have raised. We've raised it in a couple of different ways. One is the actual calculation of how did you get to your numbers? And there is without doubt evidence attached to plaintiff's motion. And it provides all different ways to calculate the damages. The problem is we don't know what was used when. So in other words, there is a standard rate of interest, there is a default rate of interest, there is a late fee, and there is a default fee. We don't know when the default rate of interest changed, if it changed, or to what months a default rate of interest was applied. We also don't know with respect to the late fee and the default fee, whether the full amount or some lesser amount was charged. And this is important, especially in light of the fact that the note contains a provision that's a usury savings clause that says, no matter what, we're not going to charge you a usurious rate of interest. We don't have any way of knowing whether or not a usurious rate of interest has been charged, because part of that analysis would require knowing what interest rate was charged and what late fees were charged and when. Additionally, attached to Mr. Diaz's affidavit are statements that he received from the plaintiffs around the time of the foreclosure. So we have objected to the valuation that's stated in the declaration of Mr., I believe his last name is Altig, for plaintiffs, wherein he states, this is the amount of the sale, and this is the amount that was due after the sale. And the amount that he says that's due after the sale is $389,000 and some change. However, 3 weeks after the sale, Mr. Diaz receives a statement from the plaintiff that says he either owes a past due amount of 1.56 million, or a total balance remaining of 7.06 million. So very different from that $389,000 number that's in the in the plaintiff's declaration. The following month, so approximately 50 days post foreclosure, there's a different balance due that has adjusted downwards, but it's even less intelligible because it says the current balance remaining is, or the current balance due is 1.487 million, or the total balance due is $407,000. So yes, there is confusion, but the confusion is because of what plaintiff has sent to defendants about plaintiff's own account. Now, the thing that's not attached to plaintiff's MSJ is any sort of accounting, anything that lists amounts of interest or rates charged or when, or payments applied, or anything of that nature. So that's the basis for our statement that, you know, you just haven't proven that you are owed this fixed sum of money. The note itself isn't even clear about what dollar amounts will be charged when, only that they may be charged automatically by plaintiff upon the occurrence of certain things. When we get to the valuation of the collateral, and that's responsive to the motion to strike as well, where again, Mr. Diaz is the managing member of Arev LLC, and at the time of the foreclosure, Arev LLC was the owner of the property. He has requested via an amended answer filed in September requesting a valuation. I'm sorry, if you'll give me just a moment.
Judge, for time's sake, may I take this moment to reply a few things?
I've got pulled up the last portion that I have, which is another thing that Mr. Diaz attests to is having received an email from plaintiff in February of 2023, that is approximately 8 months before the foreclosure takes place, wherein they're still trying to work on a workout for the loan and figure out a way, if there is a way, for the loan to be paid structured differently. And in the document reflecting the loan calculations, it suggests that the value of the collateral is close to $8 million. And 10 months later, or 8 months later, they sell the property at foreclosure to where there's a single bidder and it's them for $6.6 million. So that's a difference of $1.4 million in 8 months' time. And that's related to the dollar amount that they thought the plaintiff thought property was worth in February of 2023.
Right, Ms. Boyle?
Yes, so regarding the emails with the amounts that are allegedly in error, those don't, I mean, confusion doesn't create a fact issue because the plaintiff's not alleging that defendants owe that amount. So those are completely irrelevant. If some type of email was sent reflecting a remaining balance that's higher than what we're alleging, that it's completely irrelevant. I don't understand how that's summary judgment evidence. So confusion on the part of the defendant doesn't create a fact issue. The facts are exactly what we allege. That's exactly what they owe. And they haven't put on any evidence showing that they owe something different. All they've done is just state through an unsworn declaration that they're confused. Further, as to the foreclosure, that was the highest bidder. That whatever the highest bid is doesn't have to correlate to what someone thought the market value was 8 months prior. 6.6 million was the highest bidder. So none of this disputes our facts. They've had plenty of time because, again, this case has been on file for well over a year at this point. They were late to answer. They pushed this hearing out by nearly 2 months at this point. There was time to go find facts to dispute ours as to the amount, and there's just not. They're just saying that they're confused, and we're not alleging that they owe any amounts that might have been sent to them via email.
Your
All right,
Honor, we're not confused about the calculation. We don't believe that plaintiff has properly calculated the amount due, and we know that they were either wrong on multiple occasions when sending statements, or they're wrong in their affidavit now, as those dollar amounts do not match each other.
But again, Your Honor, those emails, whether they were right or wrong at the time that they were sent, they are not at play here in our motion for summary judgment. We are not using them as a basis to allege that that's what defendants owe. What we think the defendants owe is clearly in our MSJ. Additionally, they did have 3 notices stating the amounts, the interest rates that applied, and the fees that applied in 3 different notices that they received throughout this process, which are attached as exhibits to our motion for summary judgment.
All right, counsel, I'm going to review the summary judgment record and go through everything that's in the record before I make up my mind. And once a decision's been made, you will hear from my staff.
Okay.
Until then, I don't need anything from you. I think you both made your positions very clear. So thank you for your time this afternoon. You are excused from the virtual courtroom.
Thank you, Judge.
Thank you, Your
Take
Honor.
care.